There is a very specific kind of pain associated with buying a car. You sign the papers, you get the keys, you drive off the lot, and you immediately know, just by crossing that curb, that you've lost money.
Yeah.
We all accept depreciation. It's just part of the deal.
Right. It's the cost of doing business, essentially.
Yeah.
Cars are depreciating assets.
Exactly. But today, we are looking at a stack of documents that describes a much more aggressive, a much faster way to lose thousands of dollars. And the really terrifying part is, in this scenario, you didn't do anything wrong. You're not buying a lemon. You aren't neglecting your oil changes. You're just sitting in traffic.
Specifically Texas traffic, which, as anyone listening knows, is basically a contact sport.
Oh, absolutely. So let's just set the scene based on the intro to these notes. You're cruising down the West Loop in Houston, or maybe you're stuck in that gridlock on the North Central Expressway in Dallas.
Always a nightmare.
Right, and you're in a 2024 Ford F-150. It is your baby. Leather seats, pristine paint. Maybe you've even got a lift kit on it. You are stopped dead in traffic. And then, bam.
The classic rear-end collision. It is the most common accident on the road by far.
You get out. Everyone is physically okay. You exchange insurance. You take the truck to a top-tier body shop. And fast forward 3 weeks, the truck looks perfect. I mean, they match the paint. They replace the bumper. They even align the frame perfectly. Yeah. You get the keys. You drive off, and you think, well, that was a massive hassle, but I'm back to normal.
And that right there, that is the psychological trap.
Yeah.
Because you are absolutely not back to normal.
And that's exactly what we're diving into today, the secret loss. Because 2 years later, when you go to trade that truck in, the dealer pulls the Carfax. And he doesn't say, wow, great repair job. He says, I see this major accident on the report, so I have to knock $7,000 off your trade-in.
Yep, and just like that, $7,000 evaporates from your net worth. Just gone.
So today's deep dive is all about inherent diminished value. We are looking at specifically how this plays out in Texas, the rigorous 17C formula that insurance companies use to lowball you, and most importantly, how to build what the source is called the banker's file to get that money back.
It's really a guide on how to stop being a victim of the insurance business model, because that money is entirely recoverable, but only if you know exactly which levers to pull.
Let's start with some definitions, because I think a lot of people, I know I did kind of conflate this with depreciation. Like if I drive a car for 3 years, it's worth less than when I bought it. That's just physics and time. How is diminished value different?
So depreciation is a function of time and use. Every mile you drive, every month that passes the asset degrades slightly. That is expected. The market prices that in. Diminished value, or specifically inherent diminished value, is a stigma loss.
Stigma loss. That sounds like a scarlet letter for your car.
It basically is. It's an immediate drop in market value that occurs the split second. The accident is registered purely because the vehicle now has a history. Even if the repair is 100% perfect, even if the car is arguably better than before because it has brand new parts, the market views it as damaged goods.
Well, put yourself in the buyer's shoes. If I'm walking onto a used car lot and there are two identical 2024 F-150s side by side, same color, same trim, same 20,000 miles. One has a clean history. The other has the Carfax report that says severe rear-end collision airbags deployed, frame repaired.
Which one are you buying?
I mean, I'm taking the clean one every single time, unless
what?
Unless the wrecked one is significantly cheaper.
Bingo. How much cheaper does that wrecked truck have to be for you to risk it? $2,000. $5,000.
If the frame was actually bent and repaired, I'd probably want like $7,000 or $8,000 off.
That number, that exact discount you just demanded in your head, that is the diminished value. That is the market quantifying the risk of buying a wrecked car. And here's the kicker for our Texas listeners. Under Texas tort law, that loss is recoverable. You are owed that money.
Because of the concept of being made whole, right? I saw that phrase pop up a lot in the legal breakdown.
Yes, it's the absolute foundation of the law here. There's a landmark case, Thomas v. Oldham. The Texas courts affirmed that the measure of damage is the difference in market value immediately before the crash and immediately after.
So if the insurance company pays the body shop $12,000 to fix the metal, but my truck is now worth $7,000 less on the open market, I haven't been made whole.
Precisely. You've been made fixed, but you haven't been made whole. Your net worth is lower. And the insurance company for the at-fault driver, and to be clear, we are talking about third-party claims here where the other guy hit you, they are liable for that gap.
Just really quick on that. What if I hit a tree? Is that a first-party claim?
Yes, that's a first-party claim. And standard Texas auto policies generally do not cover diminished value for your own repairs unless it falls under an uninsured or underinsured motorist coverage. So if someone without insurance hits you, you might be covered. But if you hit the tree, you're out of luck on the diminished value.
Okay, got it. So back to the third-party claims. The other guy's insurance is liable for the gap. But they don't just volunteer to write that check, do they? Like,
Yeah.
they don't send a sorry about the value drop card with a check inside.
No, they definitely do not. In fact, if you ask for it, they will likely try to shut you down with something that sounds very official and very scientific. It's called the 17C formula.
This was the part of the research that really blew my mind. It sounds like a droid from Star Wars. The 17C formula, what actually is it?
It is the insurance industry's favorite weapon. It's a mathematical formula used to calculate and usually drastically minimize diminished value payouts. But here is the secret they really don't want you to know. It comes from a class action lawsuit in Georgia.
Georgia. We're talking about Texas law. Why are we talking about Georgia?
That is exactly the right question. So back in 2001, there was a case called State Farm v. Mabry in Georgia. The court needed a way to process thousands of claims quickly for that specific lawsuit. So they sanctioned this formula as a temporary measuring stick just to get through the massive backlog.
So it was just a quick fix administrative tool for a case 25 years ago in a totally different state.
Yes. But the insurance companies realized, hey, this formula produces really low numbers. Let's just use it everywhere. So now if you call an adjuster in Dallas or Austin, they'll say, well, according to our 17C calculation, we can offer you $300.
Let's look under the hood of this formula. Why does it produce such low numbers? What's the math doing that screws the driver?
It's flawed on almost every single level. First, it applies a completely arbitrary cap. The formula says the base loss in value cannot be more than 10% of the NADA retail value.
Hey, why? 10%. Is there any actual data that says a car can never lose more than 10% of its value?
None. Zero. They just picked a number. So if you have a brand new Porsche that gets utterly crushed, the formula says, sorry, the maximum loss is 10%. It basically assumes that no matter how bad the wreck, the car miraculously retains 90% of its value, which we know just isn't true.
That seems incredibly convenient for them. And, frankly, insulting if you have a high-end vehicle.
Oh, it gets worse. The formula relies on NADA values. But if you actually open the NAD guides, there is a disclaimer that explicitly states they do not track diminished value because the data just isn't available to them. So the formula uses a data source that literally says, do not use me for this purpose.
It's like using a thermometer to measure how far you drove.
Yeah.
It's just fundamentally the wrong tool.
Exactly. But the real gotcha, the part that makes statisticians pull their hair out, is the double mileage penalty.
Explain that. Because high mileage usually does mean a car is worth less, right?
Yes, it does. But think about how NADA works. When you look up a car's value, you input the mileage, and NADA gives you a price that is already adjusted for that mileage. A car with 100,000 miles has a lower book value than a car with 10,000 miles.
Right, the starting price is already lower.
Correct. The 17C formula takes that already reduced value, applies the 10% cap, and then applies a second mileage modifier. So they reduce the payout again based on the exact same mileage. You're literally being penalized for your miles twice.
So if I have an older, reliable car with high miles, this formula might literally calculate zero damages.
It happens all the time. In the notes, there's an example where a mileage modifier of, say, 0.5, 7 or lower just zeroes out the claim entirely, as if a high-mileage car can be smashed to pieces and lose no value whatsoever.
That's absurd. A Toyota with 150,000 miles still has significant value, and if you wreck it, it has less value. Zero is definitely not the number.
Exactly.
So if I'm on the phone with an adjuster here in Texas, and they say, well, we use the 17C formula, what is my immediate response?
Based on the research, your response should be, I am in Texas, not Georgia. That formula is not law here, and I demand the actual market loss.
You just have to reject the premise entirely.
You have to. If you accept the formula as the starting point, you've already lost. You're just negotiating over crumbs at that point.
Okay, so we know the formula is a trap. We know the law is on our side. But knowledge isn't a check. How do we actually force them to hand over the money? The sources talk a lot about building a banker's file.
This is the crucial mindset shift. You cannot win a diminished value claim by arguing fairness or sending emotional emails about how much you loved that truck. You win by proving it. You need to treat this exactly like a business transaction.
So what exactly goes into this banker's file?
Step one is the repair file, but not just the final receipt. You need the original estimates, the final invoice, and most importantly, you need the supplements.
Supplements. You mean like the extra charges the shop adds on?
Yes, but think about what they actually represent. Supplements are the additional requests the body shop made after they started taking the car apart. Maybe they thought it was just a cracked bumper, but then they took it off and realized the impact bar was crushed, or the frame rail was bent.
Ah, so the supplements tell the true story of the severity. It proves to them it wasn't just a minor fender bender.
Exactly. If the repair bill went from $2,000 to $8,000 because of supplements, that is hard evidence that the damage was severe. That scares buyers. That increases diminished value. You want that paper trail to show the adjuster, look, this was a major structural event.
Okay, repair file check. What about the car itself?
You need to prove the pre-loss value. This is where people get really lazy. The insurance company will try to claim your car was just average or dealer condition, which in their language usually means average. You need to prove it was a cream puff.
So dig up the old oil change receipts.
Everything. Tire rotations, detailing receipts, maintenance logs. If you have a photo of the odometer showing unusually low miles or a photo of the truck shining in the driveway from a month ago, put it all in the file. You are building a rock-solid case that says this wasn't just a truck, this was a pristine asset that your client destroyed.
Okay, I've got the proof. Now I have to make the demand. And the sources are very clear that this shouldn't just be an angry phone call or text message.
No, it needs to be a formal written demand letter.
What does a winning demand letter actually look like?
It's concise. It's highly professional. It starts with a very clear summary of liability. Your insured hit me, here is the police report to prove it. Then it lays out the specific numbers. Based on market data, my vehicle's value before the loss was $45,000. Its value now with this accident history is $38,000. You owe me the difference of $7,000.
And you give them a firm deadline.
Always. You write, I expect a response within 15 days. It shows you know the game and you aren't going away.
Let's role play the response, because the adjuster isn't just going to immediately cut the check. They have scripts they follow.
They absolutely do.
Okay, I'm the adjuster.
All right.
I see your demand letter. I call you back and say, look, we paid the body shop. The car is practically brand new. There is no physical damage left. We aren't paying for theoretical losses.
Then I respond directly with case law. I'd say the physical metal is fixed, but under Parkway Covey Woodruff, inherent diminished value is a recognized recoverable damage in Texas. The market value has dropped purely because of the history. That is not theoretical. That is the market reality.
Okay, you clearly know your stuff. So then I switch tactics. I say, fine, we can offer you something to settle this, but we have to stick to our standard procedure, which is the 17C formula. We can send you $400 today.
And I'd say standard procedure for you is not the law in Texas. 17C is a Georgia class action remedy. I am demanding the actual market loss supported by my documentation.
So it's like you have to be a broken record with them.
You have to be the squeaky wheel that happens to know the owner's manual. Adjusters handle hundreds of files a wint. They want to close them cheap and they want to close them fast. If you are easy to roll over, they will roll right over you. But if you show them that you know the case names and you know their math is rigged, they often move you to a different bucket, the bucket of people they actually need to negotiate seriously with.
Now, there is a level above this. Sometimes your own research just isn't enough to get it done. The sources mention bringing in a sword, a professional appraisal. When is it time to actually spend money to get money?
It's a straightforward cost-benefit analysis. Look, if you're driving a 2014 Honda Civic with 120,000 miles, the diminished value might only be $500. It doesn't make any sense to pay an appraiser $400 to prove that.
Right, you barely break even. You're just throwing good money after bad at that point.
In that case, you just use comparable listings from AutoTrader or CarGurus to show the adjuster the price difference. But if we go back to that 2024 F-150...
or a luxury car or anything with significant frame damage.
then absolutely you need a pro. But not just any pro. You need someone who produces a USPAP compliant report.
USPLP. Break that acronym down for us. What is that?
It stands for Uniform Standards of Professional Appraisal Practice. It is the federally recognized ethical and methodological standard for appraisal.
Why does the insurance company care about a federal acronym?
Because a USPAP report actually holds up in court. An online calculator printout does not. A hastily scribbled note from your buddy who sells cars does not. If you hand an adjuster a USPAP report, you are signaling to them, I have evidence that is admissible in a justice of the peace court right now.
I see. It completely changes the conversation from, I think my car is worth less, to here is legal verified proof my car is worth less.
Exactly. It removes all the emotion and replaces it with verified methodology. It is a very powerful tool in a tough negotiation.
Before we wrap up, we need to talk about the danger zones. There are a couple of crucial nuances in the source material that could really trip people up. The first one is about a total loss.
Yes, I see this confusion all the time. Listeners hear this very clearly. Diminished value claims are for repaired vehicles only.
So if the car is totaled, you cannot claim diminished value.
Right, because you don't own the car anymore. The insurance company buys it from you. If it's a total loss, you fight over the actual cash value, which is what the car was worth right before the crash. But you can't have diminished resale value on a car you aren't actually reselling.
That makes sense even if it feels a little unfair in the moment. And what about the timeline for all this? Can I file this claim 3 years later when I finally go to sell?
No, you cannot. The Texas statute of limitations for property damage is exactly 2 years, and the clock starts ticking the day of the wreck. If you wait until you trade the car in 4 years later to realize you lost money, you are legally too late.
Okay, now for the big one. The sources call this the injury trap. And honestly, this was the most sobering part of the reading for me.
Right.
We've been talking about getting money for the car, but this mistake could cost you way, way more.
This is absolutely critical. In Texas, there is a legal concept called res judicata. It's basically the rule against splitting claims.
Splitting claims, what does that actually mean in plain English?
It means the law generally views a car accident as one single continuous event. You have damages from that event, some to your car, which is property, and some to your body, which is personal injury. But legally, they are often tied together.
So let's play this out. I have a wreck. My neck feels a little stiff, but I'm mostly worried about getting my truck fixed.
Yeah.
I rush to settle the diminished value claim because I want that $2,000 check quickly.
And to get that check, the insurance company sends you a standard release form. It's full of dense legal jargon, but it basically says, I release the insurance company from all claims arising from this accident.
I sign it, I get my $2,000, and then 2 weeks later, my neck completely freezes up. I go to the doctor, they do an MRI, and I find out I need major surgery.
You might be completely out of luck. You might have legally closed the book on the entire event. You got your $2,000 for the bumper, but you just signed away your right to have your $50,000 spinal surgery covered.
That is terrifying, especially because adrenaline masks injuries so well, you might not feel the real whiplash for a week or more.
Exactly. And the insurance companies know this. They would absolutely love for you to sign a broad release quickly. The advice from the sources is absolute here. If you have any physical symptoms, neck pain, stiffness, headache, tingling, do not try to be a hero and handle the property. Claim yourself in a rush.
Just stop the entire process.
Stop. Consult a legal or medical professional. Keep the claims open until you know the full extent of your health issues. Priority 1 is your body. Priority 2 is the truck. Never, ever let the desire for a quick property check jeopardize your medical coverage.
That's a massive red flag to end on, but a really necessary one. It puts the whole winning against the insurance company thing into perspective.
It's the most important takeaway of all. Don't win the battle for the fender and lose the war for your own health.
So looking back at this deep dive, it's honestly frustrating how systematic the underpayment is. It's not an accident that they offer you 17C. It's a calculated strategy.
It's their business model. They rely heavily on the fact that 90% of people are just relieved to get the car back from the shop. They bank on you not knowing what inherent diminished value even is. And they bank on you accepting the Georgia formula because it looks like complex math.
But now you know. You know the metal is fixed, but the value is not. You know that 17C is a trick. It's not a law. And you know that you need a portal, bail estimates, photos, maintenance records to actually prove your case.
Knowledge is the only leverage you have in this fight. Without it, you are basically asking an insurance company for a favor. With it, you are demanding what is legally yours.
I want to leave you with one final thought to chew on. We talked about how the 17C formula is mathematically broken. It penalizes you twice for mileage. It uses data that explicitly says it shouldn't be used. Now, insurance companies employ some of the smartest actuaries and mathematicians in the entire world. They know numbers better than anyone.
They certainly do. Their entire business is built on probability and statistics.
So if they know the formula is mathematically flawed, and they know it's not the law in Texas, why is it still their opening offer on every single claim?
Because it works. It works on anyone who hasn't listened to this deep dive.
Don't be the person it works on. Thanks for listening. We'll see you on the next one.